Sylvia Noriega. Thank you. Cameron Scott. Eric Rodriguez. Thank you. Zachary Gilmore. Thank you. Marco Marino, custody.
Counsel is present.
Xavier Chamberlain, custody. David Huff, custody. David Saldivar Salazar, custody. Jonathan Kane Allen, custody. Vanessa Rubio, is she in custody?
Yes.
Brandon McCaskill. Brandon James McCaskill. All right, Baldemaro Joseph Chapa.
Counsel is present. I'll let you know about your.
All right. David Escobedo. David Moses Escobedo. Alex Russell Bacon. Lily Herrera. Brandon McCaskill. All right, is there anyone present whose name was not called or you came in late? Yes, what's your name?
Joshua Albright.
Joshua Albright. Do you have a case number or SID number? What is it?
I don't know the SID number off the top of my head.
Who's your attorney?
Butler.
Butler who?
Sorry, can I look it up real quick?
Sure. Just have a seat. We'll get back to you. Anyone else? All right, everyone. These are the rules of the court. Number one, you're going to need some extra patience in your pocket because Odyssey is not working appropriately, which I think we all knew that this would happen. I was told that there was a backup plan. I have never seen the backup plan. I'm not the person who installed Odyssey, so I have absolutely no control over that. I'm not a computer expert, so you're going to have some patience in your pocket. The other thing I was told by an attorney, thank you, Mr. Maurer, is people who are being sentenced, just so you can let your family know, once a judge has sentenced your relative, if somebody calls and says, if you give me $4,500, I can get them out of jail because there's this new law. There is no new law. So it would probably be best for your relatives, if somebody's calling you, asking you for $4,500, to call the previous attorney and ask them what this is about, and they will be able to tell you that it's a scam. Do not give money without asking questions. Do not give money without doing your due diligence. Otherwise, what's going to end up happening is you're going to be out of $4,500. Your grandmother is, or somebody else is going to be out of money. So don't let that happen to them. And it'll probably take an act of Congress to find the person who took the money. So let's not do that. We are going to be recessing at 12. I say that every day, but today it's going to happen. So everyone, the files are there. The files are here. Grab your file, confer. You're not ready to approach the court unless you confer with the state and confer with your client. If your client is in custody, ask the deputy to have them brought out and we will take you up, and we will take you up as quickly as possible. Hopefully at some point today, Odyssey will return to us. But if not, we're going to go old school, which people don't know how to go old school, but we will.
On my case,
If you'll have them pull the file.
I don't think there's a file. It's a trial setting, and we're ready.
No, they should have a file.
And there's not a file. And I can't look at Odyssey right now, either. It's a paper copy.
All right, see, here's the thing. And this is not for you. This is for Commissioner's Court and everybody else who decided to do this Odyssey system. Nobody has a backup plan if Odyssey isn't working. And I kept saying, if you load up every file in Odyssey and it breaks down and you don't have a hard copy, then what do we do? This is what we do. You know, nobody's MacGyvering.
It's the Bear County way.
It's the Bear County way. So who is your client?
Jonathan Dreamer. It's a.
Jonathan Dreamer?
Yes.
If you'll come forward. Hello, Mr. Dreamer.
Hello, good morning.
Good morning. All right, you're scheduled for jury trial, correct, counsel? And state, are you ready for trial?
We're ready, but CTD is obviously still in trial.
Well, we can do two trials at once, but we're not. All right, Mr. Maurer, this is what I'm going to want to happen. I'm going to have him recalled for tomorrow
Okay,
so we can see where we are on this trial, and hopefully by then we'll have the Odyssey system up and running.
okay. I'm starting in Wilson, but it shouldn't take very long and I'll just. But you don't, we wouldn't start till the afternoon like last time anyway, right?
Yes.
Okay.
All right. Norma,
Yes, ma'am.
I need a reset for tomorrow for Mr. Dreamer, and it's for trial. All right, thank you.
Yes.
Yes.
Just to give you a heads up, with the network being what it is.
Carbon copy ones.
Oh, yeah, bring out the carbon copy. But yeah, you all are gonna have to go old school.
Two minutes.
Yes.
How are we gonna do this until they're ready to?
Oh, they're just gonna say they're ready to approach and I'll take it up. And if your client is here. Ah, who's your client? Who's your client?
And then I do talk that.
Okay.
Yes, I reviewed it already. Yes, I did.
If I have to.
Have fun with no Odyssey, Joe. So I carry a piece of paper in my pocket.
Oh, yes. And you know what's so funny? Nobody knows how to go old school.
No.
And old school is like you pull up your police reports and go there.
Not with this, Martha, why do you print all these reports? I said, because internet goes down and then you don't have any reports.
Let's go home.
What time do we start back up?
Right now, my 12, so starting at 30.
Boy.
Starting with you tomorrow.
Oh, Christine, there's no witness on Zoom.
He's logging on.
Okay.
He is logging on. Is there a task?
Okay, I'm not texting. Okay, no, please.
I have no idea. Everything that was.
See mind if I check and see if that order is there, if you have their files on there, Rodriguez. I can't, if not.
State,
You said that. You have it.
Oh, it's not.
They should be written files. Or have to go on the back.
do you have the plea paperwork on Marco Marino?
Ashley's got it. She's coming down right now.
Yes. I have to.
Yes. Hi, Mr. Cavazos.
Good morning, Judge.
Good morning. So Odyssey is down. Who do you have?
I have Eric Rodriguez. He's got 2 cases on the docket.
Eric Rodriguez, if you'll come forward, please. Okay.
Yeah, we're trying to locate them, so.
Because I had them yesterday. I had the files. They should be visible files.
Hello.
Morning.
Morning. A day without Odyssey. Is it a joy? I don't know. We shall see.
I thought it was just me this morning. I didn't realize it was everybody's.
Oh, no, everybody. And you know, I don't believe there's a backup plan.
Why would we plan for that, right? That goes against everything we stand for.
And you know, whenever I bring up backup plans, because I'm always thinking you should think of worst case scenarios, right? My questions were never answered. Like, what's the backup plan? You're making more room because all the files will be gone. But if Odyssey fails, what's the backup plan? And guess what? There's no backup
There is
plan.
none.
Yeah. So, Mr. Cavazos, just be
Yes, ma'am.
patient with us. We're trying to see if there's a physical file.
Yes, ma'am.
There may be a physical file, there may not be. But what are we here for today?
Judge, there were a couple things. One, Mr. Cavazos has filed an amendment to Mr. Rodriguez's bond. It was something, essentially it involves, previously, Mr. Rodriguez was unable to see his child without supervision.
Okay, I remember you all discussing this with me.
Yes, ma'am. And the state did look into it. I did talk to the mother of the child. We have no concerns about amending that condition. I think you would ask Mr. Cavazos to get the CPS order as well as maybe some other
Yes.
paperwork, which I believe he has supplied to. So the order then was given to the court, but I believe you may have been in trial at the time.
Yeah.
So I think we had reset it till today for you to make a decision on
And does
that.
he have a pretrial services officer or no?
I believe he does, but do you know, does he have? a
Eric, who's the individual that you report to?
I can get you the name on the phone.
Okay, well.
I can meet it today.
Yes, who is the person?
I'm gonna get the name, man.
All right.
She's loading.
Technology. It's all around. So
Oh, it is.
How often do you report, Eric? Can you answer that?
Once a month. I have to report today.
There's two.
All right, thank you.
I mean. Yeah. I know.
Officer Mendez, Officer Mendez,
I'm sorry, who?
Officer Mendez.
Let me see. What's the first name?
It doesn't show, it just says Officer Mendez, pretrial services.
Would it be Celeste Mendez?
Word on it.
Let me try. Maybe it's, but it also could be Roman.
Do you have a phone number or an email for them, Eric?
It's a 188 number. I don't think it's gonna work. Call it.
No, it shouldn't be an 8 number.
Or I get a text a reminder every month.
All right, well, do me a favor, text them and tell them that the judge wants to speak to them. All right, we're going to go on the record. Court is calling 2021 CR 0735 State versus Eric Rodriguez. Can I have parties announced for the record?
Stephen Spear for the state.
Jaime Cavazos for Mr. Rodriguez. There is another case also, Judge, on your docket for Mr. Rodriguez.
Yes,
And
I'm
then-
sorry. And also 2021 CR 0699.
Correct.
And are you Mr. Eric Rodriguez?
Yes, ma'am.
All right, so we're here for, the first thing we're here for, it's in regards to having contact with your son, is that correct?
Yes, Your Honor.
All right, and your counsel in the state did discuss with the court what the issues were. The court wanted certain items given to the court before I make a decision on whether or not to grant the defense's motion. My understanding is that the state, you're in agreement with the defense's motion?
That is correct. We have no objection to the motion.
So the court wanted proof that the Child Protective Services case was closed, or there was no concern from the worker defense. Our systems are down. You're an officer of the court. Can you tell the court, do you have that information?
Yes, Your Honor. I believe I'd actually forwarded to Your Honor via email. And in addition to that, a statement from the biological mother of the involved child, wherein she expressed to the court that she had no concerns or reservations with Mr. Rodriguez being unsupervised with her child.
All right, and have the visits been supervised prior to this?
Yes, Your Honor, they have.
All right, and how old is the child?
Eric, can you help us with that?
He's 12 right now.
He's 12?
Yes, ma'am.
All right, so I believe and there's some sort of child custody arrangement?
That I'm not 100% sure. That's my understanding, but perhaps defense or Mr. Rodriguez could speak to that.
All right, defense, is there a child custody arrangement?
Mr. Rodriguez, could you answer that question? Is there a court?
You want to
court
raise your
order?
right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Eric Rodriguez?
All right, is there some sort of custody agreement, legal custody agreement between you and the child's mother?
Yes, ma'am. We have joint custody. I get them every other week.
Every other week?
Yes, ma'am.
And can you tell me, was the custody arrangement in place before or after the alleged incident that you're here for?
It was before the incident.
All right, so after the alleged incident, were there changes in the custody agreement?
No, ma'am.
All right, but there was Child Protective Services involved?
Yes, ma'am.
All right. And Child Protective Services, did they have you do some sort of service plan or no?
No, ma'am.
All right. But did they interview you? What did Child Protective Services do?
Yes, ma'am. They interviewed me, my child, my family, and it was closed the next day.
All right.
Your Honor, I believe Child Protective Services made the decision to close the file back in 2021. I don't know the exact date, but it occurred very early on. And there was no motions to modify the court order possession order by the mother because she had no concerns.
All right. Well, I will tell you this, if you all will write an order, the court then will sign the order and grant it. There are no orders attached to your motion for some reason. I believe that's another Odyssey glitch.
Well, Your Honor, I believe we had the order in back offices but I just don't know where the order actually ended up. Because it was before the file actually made it to the court.
They're somewhere in Odyssey.
Oh, okay.
We'll regenerate an order, Judge.
Oh, yes.
With
And I don't need the entire motion, just an order. And if you can send it to me, and you can send it to my email.
Okay.
And well, actually send it to the coordinator's email.
Will do.
I'll put it in the chat. There's no dot in your email, is there? All right. Okay. Now, then the next thing we need to take up is the motion for continuance.
Yes, Your Honor. This
Yes.
case went first to the trial court, obviously, the 226 then, and a motion to suppress was granted. The state appealed that decision to the fourth court, which affirmed. There was 4 issues that were before the fourth court of appeals. And the decision was to affirm the trial court's ruling. The state appealed the fourth court's decision to the Court of Criminal Appeals. And the Court of Criminal Appeals dealt with one issue and one issue only, and specifically said in its ruling that it left the other issues undecided. To be, or basically they didn't deal with them at any way. And for whatever reason, the Court of Criminal Appeals in its order indicated that the file should be sent to the trial court rather than the fourth court of appeals to deal with the remaining issues. Defense counsel that's handling the appeal out of Austin, Mr. Schulman, filed a motion for reconsideration and for clarity as to where the Court of Criminal Appeals is directing the file to be sent to. And there's been no decision on that motion as of today.
All right. And when was that motion filed with the fourth court? If you know, approximately.
With the fourth court or the decision?
I'm sorry, the Court of Criminal Appeals.
I believe that was. I'm looking it up on my computer, Judge. Give me 1 second.
No problem.
Okay. Looks like May 15th, Judge.
Okay.
The decision was delivered on May 14th of 2025, and I received a copy of that through defense or appellate counsel on May 15th of 2025.
And what is his request from the fourth court, please? For clarification?
No, the motion for reconsideration was filed with the Court of Criminal Appeals.
Oh, so he's filed a motion to
For
reconsider?
Exactly, yes, and for clarification on the directive or the mandate as to where the case is to be sent to for further action.
All right, this is what we're gonna do. Ms. Ferguson, on this case, if you can give them a 60-day reset. And I won't, even though our work is being graded on how we move cases, I'm not gonna charge either you with the continuance use, because I know that one, your client does need clarification. And if there's a request from clarification from the higher courts, then that needs to be done before this case really moves on. So 60-day reset, please. All right, so we'll be back on September 11th. And while this case is working its way through the system, if you all can make sure that all discovery is completed.
Of course.
All right,
Yes,
is there anything else, counsel?
No, Your Honor, I'll work on that order and send it to Mr. Spear for review and signature that he's agreeable with the language, and we'll forward it to your clerk.
All right, thank you.
Thank you.
You can put it as a discovery.
Are we
All right,
excused, Judge?
you're excused. Once you sign the reset form, you will be excused. Thank you for dressing appropriately for court.
Yes, ma'am, thank you.
Thank you. Thank you, Mr. Cavazos.
Thank you, ma'am.
Thank you for hearing us. sir.
Yes,
Yes, sir.
okay. All right, who's on here on Anthony Jacob Herrera? Hi, where's your client? Oh, he needs to come up.
He's coming.
Yeah, no, he's just sitting there. People, sometimes they don't want to be a part of their own case. I'm like, come forward.
Good morning, Your Honor.
Good morning. All right, State, were you able to tender an offer?
Judge, so I previously came before this court and erroneously said that discovery was complete, and conferring with Mr. Arglios and reviewing the case myself. This case was done in conjunction with some federal officers, and it looks like some of the federal discovery is missing, and so I need to draft a plea letter to obtain that evidence.
All right, and how much time do you need?
Judge, I would request 30 days.
All right. All right, I need a 30-day reset on Anthony Herrera, please.
Thank you, Judge. Thank you, Judge.
No, you need to know what your day is.
Oh, my bad.
Do you want to know?
Oh,
Maybe you don't want to know.
hopefully, okay.
I think it's like August 19th.
All right, it's August 19th. Just have a seat and they'll give you a reset form and then you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome.
It's on.
The PG is popping out right now, Thursday, in the afternoon, so I can hold on to it.
Go back again.
Yes.
That's no problem.
Is he in jail?
No, no, no. It's.
Is he here?
No.
They have to be.
No, I'll do it.
Or have them do. You want to think that's been.
And Norma? Christine, her client. Do you know if we have a file for him? All right, thank you. All right, who's here on Zachary Gilmore?
There's a motion for early termination. I have to ask for a reset.
Okay,
July 30th, which is next Wednesday for the following Wednesday.
all right, Norma, are we able to recall this for? Yeah,
You can be my only stop that morning. I can come here first.
all right. And we already have something on July 30th? All right, we'll put you on July 30th
Okay.
and we'll take this up first.
It's not next Wednesday, but the following Wednesday.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court. Thank you.
Thanks, Shannon.
You're welcome. All right, David Escobedo. And counsel, hi, are you retained?
I am not, Judge.
You're appointed?
I am.
All right, Mr. Escobedo, is the court's understanding, based upon the counsel's motion to the withdrawal, you want to hire an attorney? All right, you have 2 weeks to get an attorney. If not, this will be your attorney. And you can speak to him or not speak to him. That's completely up to you. If you go to trial, you will go to a trial with an attorney you have not spoken to. But he's been your attorney since April. So 2 weeks, you need to have your new attorney here if you're planning on hiring one. Ms. Ferguson, I need a 2-week reset.
July 29th.
And state
Yes.
and defense, do you have all of the discovery?
Yes, Judge.
All right, if you can do an acknowledgement of discovery for me, the system's down.
It is.
So it's down. Were you able to tender an offer?
Not today, but I can get one.
All right. All right, so if you'll tender an offer today and July 30th, I'm sorry, July 29th will also be your plea deadline date. All right, once you sign the reset form, you're excused.
Okay.
All right, and they will give you an offer, counsel. Yes. And Mr. Escobedo, you need to be on time for court next time. Do you understand? All right. Let me just tell you, the other courtroom you were in, was it a district court? All right.
Come up so you can try to get that.
Sylvia Noriega. Who's the attorney for Sylvia Noriega?
It's a Mr. Glitter.
All right, why are you winking at me? You winked from the side. Here's the thing. Here's the thing. We are not on that level, so don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right, you want to take him?
Take them.
Yeah. All right, I don't understand. Why are people winking at me? We're not on that level. All right, Sylvia Noriega? Yes.
This was a motion to adjudicate that was sent a couple of weeks ago.
Mhm.
We set it to see if any of the restitution had gone to the alleged victim.
Yes.
And that's where we are now. She's been on deferred, I believe, for about 10 years.
So were you able to pay any restitution?
Well, I haven't paid any money yet because I was waiting to see what was gonna happen.
You have a motion to revoke because you haven't paid any restitution. What's going to happen is if you don't pay restitution, and it appears based upon what you've told me that you have money to pay restitution, but you're trying to see what's going to happen and hedge your bets. So we can go forward on the motion. Do you want to go forward on the motion to revoke today, counsel?
No, Judge, I think the issue is she's paid restitution, but we don't know regarding the probation, if all the restitution has gone to the alleged victim or if it's going to probation. I think that's what the issue was the last time we were in court. to figure it
Right.
out. Unfortunately, today, because the system is down, probation's unable to look at information.
Are you able to come back this afternoon?
What time?
We can have her back at 1:30 and we can see if the systems are up.
Would I be able to do it by Zoom or would you? need
Yes,
it
you can do it by Zoom. Well, you know what, let's not say 1:30 because we have trial that starts at 1:30. I tell you what, we'll recall it for tomorrow and for restitution issues. And if your client wants to appear by Zoom, she can appear by Zoom because it's a matter of restitution. And then if there's an issue, we can always reset it for a contested MTR if that's what needs to be done. All right?
Yes, ma'am. Thank you.
All right, so make sure though that you save some money in case they say that you owe restitution, okay?
Yes, ma'am.
All right, do you have any questions about anything? Thank you for dressing appropriately for court and being on time. All right, once you sign the reset form, you're excused. I'm like, oh, just tell me what the case is.
It's on Raekwon Fields, he's being transferred.
Sorry, what's the name?
Raekwon Fields.
Raycon Fields. Let me see what page it.
Transferred to 227.
All right, let me see what page he's on. Okay. And transferred where?
To 227. It's coded in his case as there.
All right. Thank you. And just let Deputy Laura know.
Thanks, Judge.
You're welcome. All right, who's here on David Wayne Huff?
I am, Your Honor. I'm ready with an NCR with the free.
Okay.
Are you ready for it, Judge?
Yes.
I think that's.
Oh, Wacon Fields, they say they're being transferred to the 227. And it's on page 6. Sure. Bye.
Good morning.
So are they seeking to withdraw this?
No, Your Honor, we're gonna plead true with an agreement to continue on probation. With the evaluations to be done in custody.
And is this a misdemeanor assault?
It is a non-family misdemeanor assault, Your Honor. And there's already an agreement in place. I'm not the lawyer on that case, but there's an agreement to dispose of that case.
And what's the agreement on that case?
90 days to do. He will have probably racked up enough time by the time he's in custody. Getting done his obligations.
All right, so you understand, if you have an agreement with the state of defense, I don't have to follow that agreement. Do you understand that? All right. Court is calling 2025 CR 003649 State versus David Wayne Huff. Can I have parties announced?
Duffy, the law for the state of Texas, Your Honor.
Matthew Finch for David Huff, Your Honor, ready?
And are you Mr. Huff?
Yes, ma'am.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
All right. Are you the same David Wayne Huff who was placed on community supervision in 2025 CR 003649 for the offense of possession of a controlled substance, penalty group 1B NA? It's in a drug-free zone on May 15, 2025 for a term of 6 years. All right, state.
Violation of condition number 1, on or about the 16th day of May 2025 in Bexar County, Texas, the defendant, David Wayne Huff, committed the offense of assault in violation of condition number 1.
All right, and how do you plead?
Sure.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is to continue probationer on probation, but to allow for all the evaluations that have not yet been complete to be completed while in custody. The state understands that there is a proposed agreement as to what will happen with the assault that defendant has just pledged true to. So continuing probation will have everything, all the cases will be taken care of, and the state believes that probationer will be able to start a successful probation journey.
All right, sure. And that's the agreement, counsel?
It is, Your Honor.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. If you'll state your name for the record.
David Wayne Huff.
All right, so Mr. Huff, they're saying that they want certain evaluations done in custody. I see that you were placed on probation in May. So why did you not follow through with those evaluations out of custody?
I was only on probation 8 hours.
I'm sorry?
8 hours.
Yes, so what happened?
Okay, so.
So you 8 hours and then this incident is alleged to have occurred?
To maybe shortcut, Judge, he went home. There were some people living in his home that he was trying to get out of his home. An altercation happened. It was people that were trying to get him to use drugs.
Judge. And he was trying to do the right thing. He told me this story and told several people that story, but he was trying to fix the problem so he could be successful, and here we are, and he's been in custody since.
Okay. It explains things.
Yes, ma'am.
Now I understand why I should follow your agreement. All right, this is what the court is going to do. The court, as previously stated, is finding violation of condition number 1 true. The court will alter and amend conditions to the following, and this is to happen in custody. A TAP evaluation and a referral to felony drug court. And I am going to order, I think somebody's already ordered you to have 120 sober meetings in 120 days. Was that previously ordered?
It was, Judge.
All right. So you're to make sure that you do that. If for some reason, because the systems are down, if some reason they release you from the Bexar County Jail, you know you're not supposed to be released, right?
Yes, ma'am.
If for some reason they release you, don't fight them over it. Just come back to this court in the morning, okay?
Yes, ma'am.
All right, do you have any questions about anything?
No, ma'am, thank you.
All right, is there anything else you need from the court?
No, ma'am, I'll be successful.
All right, if in this court to be successful on probation, communication is key, right?
Yes, ma'am.
So if you need something, let probation know. If they feel like they're not addressing it, you can always come back to the court.
Yeah.
But whatever you do, don't do this thing where you don't report, okay?
Yeah.
All right, good luck to you.
Thank you.
Thank you,
Judge.
counsel.
Have a good day.
Yes.
Judge.
Yes. Yeah.
Yeah.
All right, thank you. Just give me one moment.
There it is.
You're welcome. All right, and Norma, when you get a chance, if you could have Mr. Castagnon return. Thank you. Thank you. Baldemaro Chapa. Who are you here for?
Mr. Chapa, who is not here, Your Honor.
Ah. All right, the court is going to call 2024 CR 009634 State versus Baldemaro Joseph Chapa. Can I have parties announced?
Ashley Jones for the state.
Dante Dominguez for Mr. Chapa.
All right, this hearing was scheduled at 9 a.m. It is now 9:56 a.m. The defendant has not made an appearance. State.
The state would ask the court to issue a warrant.
All right, counsel, have you had any contact with Mr. Chapa?
Not this morning, and he has been communicative with me up until today.
All right, the court will grant the motion, remain your client without bond. If your client makes an appearance, the court will reconsider.
Yes, ma'am.
So if you want to see if you can get in touch with him before the day is out, just let the court know.
Yes, ma'am.
All right, thank you.
Thank you, Judge.
All right, I'm going to take up Jesse Garcia. Then after that, it will be Marco Marino. Thank you. Thank you for your patience. All right. Hi, who's here on Jesse Garcia? Hi, where's Mr. Garcia? Nobody wants to come forward anymore. How's it going? Yeah, I can't complain. System's down. Defendant winking at me. I don't know what's going on. All right. So you are scheduled for a jury trial We're currently in a jury trial. It may be completed today, so I'm gonna recall you.
Hold on.
Yes,
If the victim didn't show up, I had deputy make an announcement, I seem to confirm when she comes back in.
okay.
Victim didn't appear, state will announce dismissal, this one have the dismissal.
All right, and the court will note for the record that the court was tendered an affidavit of non-prosecution as well.
Yes.
And it is scheduled for jury trial today. All right, Mr. Garcia. All right, let me just tell you, they're dismissing this. They're saying that the complainant has waived prosecution. Whatever issues there are that are occurring, you need to make sure those are corrected, because otherwise you're going to be right back here. You understand?
I understand, Your Honor.
I will always tell people, you get to a point in a relationship where you want to get violent with somebody or put your hands on someone and anything else than love, then maybe you shouldn't be in that relationship. You understand?
Thank you, Your Honor.
All right. Good luck to you.
Thank you.
You're welcome. Thank you, counsel. Yes. All right, Marco Moreno. And State, on this case, do you have your file with the plea that you entered into? Do you have the plea page on this case? Yes.
Yes, Your
All right, if I could have a copy of that, please.
Honor, it's my personal copy. Odyssey is not working with me.
I'm sorry.
Odyssey is not working with me this morning.
Yeah, it's.
Should I have a hard copy? I can
Oh,
look at
yes,
it.
thank you.
Oh, perfect.
Okay, so Christine was ready for Odyssey to break down. Nobody else was ready. She was ready.
Well, I have a personal copy.
Okay. Email says, service disruption, immediate network maintenance. All right, so here's my question. And I think that group is so great. They're not the ones who decided on this Odyssey. But they're starting the service disruption today immediately. So I don't know if they decided just, we're gonna do maintenance today, or if there was an issue, then it's, hey, we have to do maintenance. Who knows? Okay, thank you. Thank you, Christine.
No problem.
All right, the court is calling 2024 CR 006824 State versus Marco Antonio Marino. Can I have parties announce?
Ashley Jones for the state. Christine Brown on behalf of Marco Antonio Moreno.
And are you Mr. Marino?
Yes, ma'am.
All right, you entered a plea in this case to count 1 of no contest on May 27th. According to your plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. The state is opposed to your application, and there's restitution. I'm sorry, and there's registration and no contact with the complainant. And there was a PSI that was completed in this case. Have both parties had a chance to review the PSI report?
Yes.
Any objections?
The defense objects on page 3 where restitution is discussed. If you were to look at the plea bargain paperwork, restitution was never something that was brought forward by the state. It was not a term of the agreement. There has also been some concern as to the documentation supporting what is proposed as $4,000 as restitution for certain medical expenses. And I have been in communication with probation officer Gloria Medina yesterday morning, who called me telling me that no documentation was provided to her to substantiate that restitution amount. Yesterday, I filed a motion requesting a restitution hearing. As we all know, Odyssey is down and so is e-filing, so it has yet to be accepted. But that is something that we are requesting if that is something that this court still wants to consider.
All right, well, unless the court receives adequate documentation of restitution, then there's not going to be restitution. So state, do you have any itemized billing?
Your Honor, I have not had a chance to speak with our witnesses regarding the restitution. As defense counsel said, I didn't get the motion for
All right.
restitution, so.
So if both
I
parties,
just served you, but I understand it has yet to be
Right.
accepted by the court.
all right, so if both parties are in agreement, we can go forward with the PSI, and with regards to restitution, that can be determined at a later date if there is any restitution.
Yes, Your Honor.
Are both parties in agreement with that?
Yes, we're in agreement.
All right, so the state is opposed. State, do you have any witnesses?
Your Honor, no, we do not have any witnesses, just arguing.
All right, defense, do you have any witnesses?
Yes, we would like to call Stephen Thorne.
All right, Mr. Thorne is by Zoom. Any objection to the witness appearing by Zoom?
Not the state, Your Honor.
And I know you have no objection, counsel, correct?
No. No
And Mr.
objections.
Marino, do you have any objection to the
No.
witness appearing by Zoom?
No, ma'am.
All right, Mr. Thorne, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Dr. Stephen Thorne.
All right, you may proceed.
All right. Dr. Thorne, my apologies for addressing you with Mr. Pryor.
Oh, that's okay.
Could you please state your profession for the record?
I am a licensed psychologist in the state of Texas.
And circling back to your profession as a licensed psychologist, where is your place of employment?
I work in a lot of different areas across Texas and other states, but my office is in Austin, Texas.
And so are you self-employed?
Yes, ma'am. I'm in private practice.
And how long have you been in private practice?
I think this August, I think next month will be 23 years, I believe.
And how long have you been a licensed psychologist in the state of Texas?
That same amount. I think in August it'll be 23 years. So.
Are there other states in which you have licensing?
Not full-time, like to a lot of states, if I go testify in those states, I'll have to have like a temporary license. So at any point in time, I may have like temporary license in a couple of different states just when I go testify there, but not full-time.
And what is the extent of the education and training received to obtain your credentials?
I have a bachelor's degree in psychology from Austin College in Sherman, Texas, just about an hour north of Dallas. And I have a PhD in clinical psychology from the University of Texas Southwestern Medical Center at Dallas.
And are these specialized degrees?
Yes, ma'am. I mean, the undergraduate degree is just a general psychology degree, but yes, the doctoral degree is in clinical psychology.
And Dr. Thorne, could you please briefly describe the subject matter of your specialty?
You know, probably at least 95% or more of my practice is forensic in nature, meaning I do evaluations, consulting, testimony, and legal cases. I testify for, the state. I testify for defense attorneys. I do work at the request of judges and probation departments. I do work for the Texas Department of Criminal Justice. So I kind of do evaluations or consulting or testimony for different parties in the legal system. And I do a few other things that don't involve the courts, but the large majority of what I do in some way involves the legal system.
And you mentioned evaluations. Could you specifically mention what kinds and the proportion of they use?
Most of my evaluations are related to sex offenses, either a risk assessment for sentencing purposes, or I do a lot of what they call the civil commitment of sexually violent predator evaluations as well. I also do things like competency, insanity, and adult certification, child custody, family law evaluations. But if there's one area that most of my evaluations and testimony is in, it's in sex-related evaluations.
All right, so just to be clear, a topic of your specialty would include sex offender risk assessment?
Yes, ma'am.
And so have you conducted personal examinations or testing of alleged or convicted sex offenders?
I couldn't hear the last part of that. Of what?
Alleged or convicted sex offenders.
Oh, sure. Yes, ma'am.
And how many of these tests, if you can provide a number more or less, how many of these tests or examinations were conducted by yours?
I mean, over 1,000, I maybe 1,500, 2,000, I'll say 1,500 just in be an estimate.
And you mentioned that this was your specialty. Do you teach or lecture in the field of sex offender risk assessment?
Yeah, not teach per se, but yes, I speak at forensic conferences for probation officers, mental health professionals, attorneys, judges, about a number of different forensic topics, including, sexual risk assessments.
And so what publications have you authored in this field of sex offender risk assessment?
I don't do a ton of writing, but I haven't published anything specific to sexual recidivism. My publications about in journal articles or book chapters have been about antisocial personality disorder and psychopathy.
And is that an aspect that you test for when you conduct these risk assessments?
Sure, particularly antisocial personality disorder is one of or antisocial traits in general is one of the primary risk factors we look at in these types of cases.
And Dr. Thorne, I know that you're virtually testifying today. I have sent you what has been pre-marked as Defendant's Exhibit 1, and I did tender a copy of that proposed exhibit to the state for inspection.
Okay.
And without telling me what it is, do you recognize it?
Is one, I believe, is a copy of the report I wrote in this case, or is one my CV? I can't.
There were two attachments.
Yeah, I'm sorry. I'm trying to pull that up. Exhibit 1 is my CV. So this is a copy of kind of our resume, our curriculum vitae.
And is this a fair and accurate depiction of your curriculum vitae or CV?
Yes, ma'am, it appears to be.
At this time, we are offering into evidence Defendant's Exhibit 1, the curriculum vitae of Dr. Stephen Thorne.
The state would just object on Thursday, he's here to testify about
All right.
clarifications.
If I could. And your objection is what?
Just here, so you're.
All right, that objection will be overruled. Defense Exhibit number 1 will be admitted.
And Your Honor, pursuant to the Rule 702 of the Texas Rules of Evidence, I am tendering Dr. Stephen Thorne as a qualified expert witness in the field of sex offender risk assessment.
He doesn't have an objection.
All right, then that will be granted, and the court will note that he's an expert in the field.
Thank you, Judge. Dr. Thorne, are you familiar with the specific risk that the risk assessment tools used in this particular case?
Yes, ma'am.
And how does this particular risk assessment work as it pertains to Mr. Moreno?
Well, they allow us to kind of collect information relating to risk factors. Like, I'll try to give a short answer, but in doing a risk assessment, we look at, are there any factors that the research suggests can increase a individual's risk for sexual recidivism or decrease an individual's risk for sexual recidivism? And so like the RSVP and the static 99R, those are two different factors or two different assessment measures that kind of help organize those risk factors and protective factors so that we can apply them to the person we're evaluating, in this case being Mr. Moreno.
And so are these forms of assessments accepted as reliable in the scientific community?
Sure. I mean, these are assessment measures that I use regardless of which side hires me. They're commonly used, commonly researched in the field. Yeah, they're
Just one moment, please.
Sure.
Sorry. All right, counsel, I'm sorry about that. You may proceed.
No worries. And so now I want to show you what has been pre-marked Evidence Exhibit 2. I have tendered a copy of that exhibit to the state. If you could access that, let me know when you have it ready.
I have it.
And without telling me what it is, do you recognize it?
Yes, ma'am.
And could you identify that exhibit for the record?
A copy of the report I wrote in this case relating to Mr. Moreno.
And when was that report made?
It was last week. I wrote it on June 5th.
You mean July 5th?
July 5th. I'm sorry. July 5th.
No problem. And is this a fair and accurate depiction of the risk assessment report you completed for Mr. Moreno?
Yeah, it sure appears to be. Yes, ma'am.
All right. At this time, we offer into evidence Defendant's Exhibit 2, the sex offender risk assessment report of Dr. Stephen Thorne.
Wait, again, objects on this, say your honor.
All right, that objection will be overruled. Defense exhibit number 2 is admitted. All right, you may proceed, counsel.
And so if you could be a little more specific, I know you provided some general details. What methods and principles did you employ in this specific risk assessment?
Well, I performed a clinical interview of Mr. Moreno. I reviewed records relating to the current offense, both the indictment, the offense report, some letters and notes relating to the offense. And then I administered various, psychological or actuarial measures, the adult self-assessment inventory, the MMPI-2 RF, the personal problems checklist for adults, the static 99R, and the RSVP.
And so you had mentioned factors that decrease or increase the likelihood of committing a sex offense in the future. Could you specifically outline what factors were examined with respect to Mr. Moreno?
Well, when looking at, again, what we call like risk factors or protective factors, and looking at some of the risk factors, he has a conviction for a sex offense or for sex offenses committed against, minor children. So that, the age of the age of the victim is important, as that's thought to be a risk factor. He does have a history of non-sexual criminal behavior, and as we referenced earlier, like antisocial traits is a particular risk factor in these types of cases. So his history of non-sexual criminal offenses is relevant to consider as well. No,
I don't want to interrupt, but I did hear you mention something about sexual offenses against children. Just to be clear, were there any, upon reviewing the history of Marco Moreno, were there any past indicators of a criminal history regarding sex offenses against children, aside from this instant case?
Yeah, not prior to this case. So when I was talking about he has a, relating to a conviction in this case for having an underage female victim, but no priors, so no prior sexual offenses.
And so based on your overall assessment, what is your professional opinion, your professional and expert opinion regarding Mr. Moreno's risk?
Well, I should say, I think you'd asked me about factors I considered. I only got to the protective factors, or only got to the risk factors. I did not get to the protective factors, if you want me to address those as well.
Sure.
Okay. The protective factors are he doesn't have any previous convictions for a sex offense. Sex offenders who have a single sentencing occasion for a sex offense are thought to have lower levels of recidivism than those who have multiple sentencing occasions for a sex offense. He doesn't have any male victims. He doesn't have any stranger victims. He doesn't have any victims outside of his family, or any documented victims, I should say. He doesn't appear to have a history of significant psychiatric issues that might increase his risk for sexual deviancy. He seems to at times have had a history of social support and had a history of ability to maintain employment. So those are some of the protective factors that we look at in these types of cases. And then his age. He's currently in an age group where at that age, we expect to see, statistically speaking, we expect to see lower levels of sexual recidivism. So those are some of the protective factors.
And so taking all of these factors into account, what is your assessment regarding Mr. Moreno's risk?
Yeah, I would say he's a relatively low risk for sexual recidivism. And, that's kind of supported again by the protective factors and the risk factors, but also the scoring of the static 99R and the RSVP. So again, my overall opinion is he's presently a low risk for sexual recidivism.
And so regarding the possibility of deferred adjudication community supervision, are you in a position to recommend any kinds of conditions that may be helpful to Mr. Moreno?
And Your Honor, I just would object that this is outside of his scope. He was listed as an expert in sexual predator recidivism rates.
All right, that'll be overruled. I'll let him answer.
I wouldn't have a lot of specific recommendations, about conditions of probation or supervision outside of, I do think sex offender treatment would be appropriate. I think research shows that individuals who successfully complete sex offender treatment, that can lower their risk for recidivism compared to those who are unable to complete a comprehensive sex offender treatment program. So My one, I guess, recommendation relating to that would be that he participate in and successfully complete, a comprehensive sex offender treatment program.
All right, no further questions. Thank you, Dr. Thorne.
Any
Yes, ma'am.
questions?
Briefly, Your Honor. Good afternoon, Dr. Thorne. Can you hear me okay?
I can hear you, but I can't see you, but I can hear you. Yes, ma'am.
Okay, well, my name's Ashley Jones. I'm the prosecutor in this case, and I just had a couple questions regarding to the risk factors that you use to give
Sure.
your opinion.
Yes, ma'am.
It seems that a multitude of them are reliant upon Mr. Moreno's self-disclosure. Would you agree with me on that?
I would, not all. I mean, some are confirmed by the records, but yes, I would agree that some of that is dependent upon his self-report.
Right, and so you would agree with me that Mr. Moreno likely wouldn't admit to any other sexual offenses if there were any other sexual offenses, right?
I don't know that I would use the term likely. I'm not trying to quibble with you. Some people do, some people don't, but I can say I'm not surprised if people don't admit to any undocumented victims. So I hope that makes sense.
It does, thank you. And as a psychologist, you would know that it's hard for kids to speak out about sexual violations that have occurred to them.
Sure. Yes, ma'am.
And so, and I think you mentioned earlier in your testimony that there are no other documented victims, but you're not saying there aren't any other victims out there.
Right. And that's exactly why I try to use that term, documented victims, documented by arrest or conviction. Because yeah, sometimes people have victims that don't result in arrest or conviction. So I try to use that specific language for that reason.
And I do believe in your report, you stated that no one factor can accurately predict whether a defendant will commit another sexual offense. Is that correct?
Yes, ma'am. Yes, ma'am.
And so you're not saying that Mr. Moreno wouldn't commit another sexual offense. You're just saying based off his self-disclosures and what you've read, the risk is low.
Yeah, first of all, I would never say that about anybody, that they will or won't commit a sex offense in the future. But yeah, my opinion about low risk is based off, again, not just his self-report, but also information in the offense report, what he's convicted of, and probably most importantly, an application of the research to his particular case. So
Yeah, and just going to the procedures used in evaluation, it was a clinical interview with him.
yes, ma'am.
Okay, an adult assessment, self-assessment, so one that he did, right?
Yes, he kind of checked yes or no to a number of items on that measure.
And then there was this Minnesota multiphasic personality inventory number 2. And I do believe in your report you stated his test results should be interpreted with caution. Is that correct?
Right, correct.
And that would be because there's history of underreporting when the self is underreporting in that test. Is that correct?
Yeah, on that particular test, it wasn't invalid. It wasn't to the point it was invalid, but it did suggest maybe a reluctance to admit certain shortcomings, weaknesses, problem areas. So that's why I, qualified that in the report.
And then the personal problems checklist for adults, that was also completed by Mr. Moreno.
Yes, ma'am.
No further questions, Your Honor.
All right, any other questions?
No further questions for this witness. May he be excused?
Yes, thank you so much for coming, Dr. Thorne.
Thank you, Your Honor. I appreciate it.
Any other witnesses?
Yes, the defendant's called Dalia attendees.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up because the court reporter is taking down everything, okay?
Yes.
All right, if you'll state your name for the record.
Idalia Resendiz.
All right, does she need, spelling? Yes, please.
It is Hidalia. Last name is Resendiz.
All right, you may proceed, counsel.
Ms. Resendiz, what is your relationship to Marco Moreno?
Marco Moreno is my brother.
And are you his older sister or younger sister?
Older.
And how would you describe your relationship with Marco?
I would describe it as a really good relationship.
And what examples could you give of how you have a really good relationship?
We would talk in the phone even if we didn't see each other very often, but even when I lived in Atlanta, Georgia, we would call from time to time. We would just text to see how we were doing, and after we moved here, on weekends, most of the weekends, we would meet up at my mother's house and just to visit, sit there, talk, and just hang out in my mom's house.
And so where is your mother's house?
She lives in 2618 West Trail,
All right, what city?
San Antonio.
And what is your relationship to the victim in this case?
To the victim in this case, she was, I considered her like my step niece,
And why would you say step-niece?
because I felt like sometimes she opened up to me and I saw her like that, like a niece.
All right, and so how often would you interact with this family, including your brother and the victim in this case?
From time to time, maybe once a month. My brother was more often, and as well as his children, but with the victim in this case would be from time to time, every now and then, even when I lived in Georgia, sometimes I would text her.
I'm sorry, could you keep your voice up just a little bit for me?
Yes, ma'am.
All right, you may proceed.
Yes.
And so what was the extent of your interactions with the victim and her family while this case was pending?
Well, I went to visit probably twice. Once, it was almost after my brother Marco Moreno was arrested.
And what were your observations during those times?
My observations, well, within the home was filthy. The home was filthy and.
How would you
Your Honor, I'm
describe
gonna
that?
object to relevance.
Judge, may I respond?
Yes.
So the Article 42A102 of the Texas Code of Criminal Procedure allows a judge to place a defendant on deferred adjudication for this offense. But what must be considered is that this would be in the best interest of the victim. We are going into a discussion that we believe would assist the court in making that determination.
All right, the objection would be overruled.
Yes, the home was dirty. It was messy. That's what I noticed.
What do you mean by dirty or messy?
There was things all over the place, including the floor, the table. There was hardly anywhere to sit.
And what do you mean by hardly anywhere to sit?
There was things all over the place, all over, like items.
How many children were in that home?
From what I saw, it was my niece and nephew,
How old are they?
6 and 9.
And who else was in that home the last time you were there?
There was a man that opened the door, or he opened the door, and then when he saw us, he shut the door, immediately shut the door. And so I don't know, I've never seen him.
So after that interaction with that man, what happened?
After that interaction, well, he shut the door, and then we continued knocking until the victim's mother came to open the door.
All right. And then without saying names, how did that interaction proceed from there?
Well, that interaction proceeded where
Well, what did you learn from that interaction?
the victim's mother was saying that
Objection to
saying
Sustain.
she was saying
Excuse me, you know, you're not allowed to repeat what other people have said. All right, so when either party makes an objection, I'm going to make a ruling. If you don't understand my ruling, just let me know. You can say, do I still continue to answer or not?
Sorry.
Okay.
Yes,
No,
ma'am.
no problem. So in that situation, you're not allowed to say what anyone said. You understand?
Yes.
All right, so that objection will be sustained.
And so without going into what anyone has said or told you, what was your understanding of the family dynamics based on your observations and interactions?
The family dynamics to me is it's I don't feel like it's a good situation there.
Why is it not a good situation there?
Based from what I saw, I feel that no children should be staying in a shelter house.
And to your knowledge, who was supervising these children, to include the victim and the
To my knowledge, a lot of times the victim was supervising the children.
And how old is the victim?
The victim, now she is 16.
How old was she when you had personal knowledge or observations of this?
She must have been about 14, 15 years old.
And just to be clear, how long have you known the victim?
It has been probably 6 to 7 years.
Right. Lisa, I want to talk more about your brother. What assurances could you provide this court if his application for deferred adjudication were approved that he has a foundation to be successful on deferred adjudication?
Well, I would, on my behalf, I would call him and go to where he would be staying. I would call him and make sure that he is following up and keep track of his, if he has any appointments with his officers or anything, I would keep up with that, find out, put it on my calendar if I have to, give him a call. And if I'm able to, I'll take him myself because I want him to succeed and I know he will.
Okay.
And where would he be staying if he were released?
He will be staying at my mother's house at 2618 Fitzgerald, San Antonio.
And what more would you like the court to know with regard to his application?
I know he is. I know he will. I know he's learned his lesson. I know he's a hard worker. And he has a lot of support at home. He does. He has a lot of support. We will all keep an eye on them and make sure that he follows through. And I know he will.
Okay.
Nothing further.
All right, State.
Yes, ma'am. Good afternoon, good morning.
Good morning.
Ms. Endes. So you're the defendant's sister?
Yes, ma'am.
Okay. And his older sister, do you have any children of your own?
Yes, I do.
What are their ages?
They range anywhere from 22 to 36. 37, sorry.
Do you have any grandchildren?
Yes, I do. I have 6 grandchildren, 1 great grandchild.
Congratulations. What are the age ranges for the 6 grandchildren?
The ages are almost a 2-year-old all the way to a 21-year-old.
And what about your great grandchild?
He's
3?
Yes.
And I think he said it's a little boy.
Yes.
All right. And I want to talk about you're here today. How do you know about, or what do you know of this offense? What do you think happened?
What do I think happened?
Mhm.
I think I'm gonna be 100% honest. I feel like they wanted to get him out of the house so he doesn't have contact with the children.
So you don't believe he did this at all?
No.
And so then you, not believing that he did this at all, you wouldn't have any concerns about bringing your children, grandchildren,
No.
great grandchild around him? Okay. Any further questions, Your Honor?
All right. Any other questions?
Yes, just briefly.
Sure.
And Mr. Sendiz, I understand that this may be a very difficult question for me to ask, but it relates to what the state has asked you. As it pertains to child abuse and the topic of child sexual abuse, what personal experiences have you had?
Objection to relevance, Your Honor.
Overruled.
Yes, you can proceed.
I have personally, my oldest daughter, when she was 13, she was beat and abused, sexually abused. So for me, if I knew my brother was guilty, I wouldn't have supported him because I know how that feels.
All right. So here's the thing. I want to thank you so much for giving me some insight into your brother. And I understand that sometimes when relatives come to testify, people want them to say that they believe this is true, right? And if you don't believe it's true, that's fine. And I'm not going to hold it against your brother that you don't believe it's true.
Right.
So I want you to know that when people come and testify, all I want them to do is tell the truth.
Yes.
And when you tell the truth, it doesn't negatively impact your brother. So the fact that you don't believe that he didn't commit this offense, that's not going to negatively impact him. I'm just trying to get some insight about him through the witnesses that are called so that I can make an appropriate decision in this case. Okay?
Yes. Ma'am.
All right. Is there anything else?
Nothing further.
Anything else? All right. Thank you so much for
Thank
coming
you.
in. Next witness.
Yes, at this time, the defense calls Juan Moreno to testify.
All right. Could we let me just take a short recess so I can take up a couple of more cases and then I'll continue.
Thank you.
All right. Thank you so much. Jesse Orozco. Hello.
Hi, Your Honor.
Hi.
Oh, I love you. That dress, pretty.
Oh, well, thank you very much. I'll let my mom know you said so.
Kind of a longhorn thing. I'm not gonna say, I'm not going there. Not
Hey,
going there.
hey, now. You were going so well. Now you just,
Hey, I couldn't help myself.
that's okay. All right, on this case, have you received all discovery?
Yes, Your Honor. We are asking for a reset. He is in recovery right now, and
Mhm.
I'm trying to gather some documents evidencing that. And I'm going to confer with the DA, and also need to look at the videos. I've not had opportunity to review those, but I see them on my discovery that they're there. So
All right. So what I'll do, since you're still looking at videos, I'm just gonna set it for a discovery date.
okay,
Another discovery date. And at the next date, the state is gonna have to be prepared to tender an offer.
okay.
All right.
All right.
Ms. Ferguson, I need a 30-day reset on Jesse Orozco, please. All right, we'll be back on August 14th
All right, thanks.
and state will tender an offer. Oh, don't leave until you get the reset form. Just have a seat. Who's here on Adrian Holmes? And where's Mr. Holmes?
He's right.
Come down. I'm so sorry. There's a report that's due, but our system is down, so I can't see
Got
it.
an update for you.
Okay, yes.
I stopped by Judge Rodriguez this morning, and they told me that the evaluation is scheduled for August 21st. And I think I've got a date in your court in September already on the computer. I haven't-
Okay,
Didn't sign anything for it. I think it's September 7th.
all right. Mr. Holmes? Yes.
It's working for me.
Oh, it's working now? Oh, thank you.
I think it might be more.
All right, let me see. All right, Mr. Holmes, I'm so sorry that it's taking so long to do the evaluation. We have a limited amount of doctors to hear cases. And sometimes the pay for the doctors is not sufficient for what they do. So many times doctors will do some of these cases as pro bono. I'm sorry, just one second. Yes, so many times doctors will take these cases as a part of their clinicals and they won't charge. But we have a limited amount of doctors in Bexar County, so the soonest we can have you evaluated according to the court that is in charge of the evaluations is August 21st. So we do have a prior setting for you in this court so that I can make sure that we stay on top of your settings. Oh, here it is. Okay, let me see. Ta-da! Thank you, Rick.
have my,
I'm sorry?
right now, can I have my time, proceeded to, I was referring to this, the time, sir?
Oh, well, here's the problem. Because of the nature of your offense too, and also legally, once there has been raised an issue of competency, you have to follow through with the competency evaluation. So legally, there's nothing I can do.
The doctors, advocates, I mean, they're doctors.
Hmm?
It's about the doctor association, excuse me, I just looked at. Yeah. Okay.
All right, so this is what I'm gonna do. Norma, he's scheduled for an evaluation on August 21st. Can you just recall this after August 21st, please?
No, I'm gonna miss the appointment.
I looked on the computer last night and I think it said we had already had a date for September 2nd.
Now, September 2nd, that may be, let me check.
Okay.
Yes, so that's not for this court.
Yeah, the court said they have 30 days to get the report in once it's the evaluation's done. So-
All right, so this is what I'm gonna do. I'm gonna recall this, Norma, if you can give me a date later in August, please. So that we can make sure the evaluation actually happened. Are you available on the 25th? All right, so we'll come back on August 25th.
Thank you.
All right, do you have any questions, sir?
How long has I've been, doing? And, yeah. August 25th.
Wednesday we'll come back here.
I'm thinking I was hoping that nice concert.
So I think he had a question about credit, jail credit.
So here's,
And when your case gets resolved. If and when your case gets resolved, Adrian, hang on. You're getting credit for all the time you locked up. Okay, so you just.
all right, Mr. Holmes? Mr. Holmes, what I can tell you is what you're charged with, the range of punishment for that offense is 2 to 20 years. So the time that you're in custody, go towards the 2 years if that's some sort of an agreement that is reached. Okay. All right. All right, Juan Aguilar. Thank you.
This is a case on requesting a plea deadline on the discovery.
Okay.
I believe I received all the discovery.
Okay, it's set for a plea deadline today.
I'm born Judge said discovery.
All right.
That's my
That,
request form was.
all right, that's incorrect, but what we'll do is I will set it for a another plea deadline date. How old are you, sir?
I'm 26 now.
All right, Ms. Ferguson. If we can recall this back in 2 weeks for a plea deadline date, please. Is that good for you? July 29th?
Can we come to 30th since I'm here on that other case?
Yes, we can put it on the 30th. We already have, I know, we already have 2 cases on there. I know, I'm so sorry. Yes. See, you know what? Give a mouse a cookie. He's gonna want a glass of milk.
Pretty much.
That is so true. You know, I didn't know that saying until I got that book for my niece. And I was like, oh my goodness. All right, so once you sign the reset form, you are excused. All right, thank you.
Thank you.
Number, what page is he on? Thank you. Who's here on Lamone? All right, on this case, where are we on discovery, counsel?
On discovery, Judge, believe it to be sufficient. I know it just got indicted recently. His first court date, I guess, is scheduled for August. However, I think we're here for the compliance hearing with regard to pretrial violation report.
All right, does anybody have a pretrial violation report on Lamone? No, I have nothing attached. This is all I have.
Oh,
Thank you. All right, have you had a chance to confer with the state?
yes, Your Honor. I did confer with Mr. Pitlock, and I brought to their attention the concerns of pretrial services. I actually spoke with Officer Grosso yesterday as well, Judge, and I know there has been some positives, Brax. My client did admit to pretrial services that he did have a relapse. Unfortunately, he did recently suffer the loss of his father 2 weeks ago, and that was a stressor for him. He is a veteran, Judge, and he has been seeing VA, so he's being seen a doctor with the VA, and he does have a scheduled appointment this Thursday. Since he is already set up with the VA and he does have some issues that he's dealing with, Judge, we wanted to see if this court would entertain doing a referral for veteran treatment court. I did notify him on the outside of the door that there is that screenshot where you can take and get more information. So he has been looking into that, Your Honor. But I do think that would be a possible good resolution to get him set up with that treatment, veteran treatment court, since he is dealing with some things and currently set up with the VA. So I did speak about that idea with the states about addressing this and moving forward in terms of potential treatment response. And they seemed on board with that possible route if he does qualify for that program.
All right, so you're not allowed to drink alcohol. Do you understand?
Yes, Your Honor.
All right, so this is what the court is gonna do. I'm gonna order that you be continued on the PAM device. There's still no driving. I'm asking that the fees be waived, and you're gonna do 90 sober meetings in 90 days. Do you understand?
Yes, Your Honor.
Here's the thing. With these sober meetings, if there's an issue and you feel that you're going to use or there are stresses in your life, that's when you need to contact the VA. That's when you need to contact whoever your sponsor is. Do you understand?
Yes, Your Honor.
And I'm going to put it in this order so they'll know. We'll do a referral to veterans treatment.
Thank you.
All right, and Norma, on this case, could you do a referral to felony drug court? Tell them that his case is still open. Veterans Treatment Court. And can I have a 30-day reset? All right, we'll be back on August 14th.
Thank you, Your Honor.
All right, thank you. Once you sign the reset form, you are excused, and make sure you follow through on everything. You understand?
Thank you, ma'am.
You're welcome. Who is here on Xavier Chamberlain?
Mr. Chamberlain?
And counsel, do you have witnesses?
No, Your Honor.
All right. Court is calling 2025 CR 0000069, State versus Xavier Chamberlain. Could I have parties announced?
Rick Payne for the state of Texas.
Renee Munoz on behalf of Mr. Chamberlain.
And are you Mr. Chamberlain?
Good morning, Your Honor. Yes, ma'am.
All right, according to the plea bargain agreement, just 1 second, we'll wait till they're finished over here. All right, you entered a plea on May 27th of no contest to assault a family household member with a previous conviction. According to the plea bargain agreement, punishment is to be assessed at a cap of 5 years. This is to run concurrent with 2025 CR 0000071, 2025 CR 0000092. Those cause numbers, have you been sentenced on those or those motions to revoke?
They're all new cases that got indicted. He doesn't have any pending motions to revoke. It's just there was a plea on as to some and then summary BTIC to resolve.
All right. All right, have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections?
No objection by the defense.
No, well, I'm silent, but I'd just like to speak.
All right. All right, do you have any witnesses?
No, Your Honor, I believe procedural background justification as to what we believe is an appropriate course of action that we would ask the court to follow.
All right,
as
just
well
1
as-
second. State, any witnesses?
None from the state.
All right, then you may proceed.
Thank you, Your Honor. In reference to Mr. Chamberlain, I have been on his case ever since he got picked up on these offenses in October. I've met with him routinely. And this is an individual that I believe is grappling in with drug addiction and does not have an innate sense of criminality, Your Honor. Ever since he's been in pending custody in the Bexar County Jail, he has done family violence individual counseling. I have those forms here, if I may show the court.
Any objection?
None from the state.
And so he has been working on those things. He has been learning about boundaries and effective ways to deal with stressors in his life as well, to not take him out in a violent way, Judge. There's some cases pending here, but if the court does take note, one of the offenses, there was no bodily injuries observed by law enforcement, and the other one, there was a small, slight little scratch. In dealing with the case and talking about the evidence and our avenues for taking this in front of the court in terms of sentencing, we did talk about certain inconsistencies within some of the reports, but that was more so before he accepted the plea. So he does accept responsibility. He knows that he messed up. He knows that this was a toxic relationship with an ex that he shouldn't have been continuing, but he was in the midst of drug addiction. As noted in the PSI, he was under the influence of drugs at the time of these offenses, Judge. Also in the PSI, he has never had residential treatments. He has had outpatient treatment before, but because we believe that his needs are severe in terms of his daily methamphetamine usage before he got picked up, we feel like inpatient treatment would be more so suitable for him to get a grasp on his issues that he's dealing with. We're looking, Your Honor, in terms of his whole life and his future down the road. And in terms of serving the community and also helping Mr. Chamberlain work towards bettering himself, we feel that inpatient treatment would be more conducive in that we're able to address the root cause of this and hopefully put a stop to this from ever occurring again. If Mr. Chamberlain is institutionalized or incarcerated without the proper form of treatment, we feel that we may just be repeating this pattern of events that has been going on. Mr. Chamberlain has been to prison before, Your Honor, but this was about 20 years ago. When he was younger, did not get the appropriate treatment. He was essentially sent to TDC, released out, and had been battling homelessness as well as drug abuse. For these reasons, Your Honor, we're requesting a period of a deferred adjudication as as long as the court sees fit with inpatient treatments. And I did speak about if the court did approve inpatient treatment, what that would be looking like in terms of transfer to a facility and then having to be compliant with the terms of community supervision thereafter. Before Mr. Chamberlain was picked up on this offense, he did start school at St. Philip's College. He was about 1 month into that program until he got picked up on this offense and did not have the opportunity to bond out. But he had been working towards his HVAC certification, where he wanted to work in that capacity in terms of a career for himself, Judge. So in looking at his criminal history, he does have minor things such as theft, drug possession, a burglary. These are all things that I think were tied with drug addiction, drug usage. So we're asking that the court take a look to see if he's eligible to address the root cause of that addiction to stop this cycle of institutionalization.
All right, is there anything you wish to say, sir?
Yes, ma'am.
You want to raise your right hand for me, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
David Chamberlain.
All right, you may proceed. What would you like to say?
Your Honor, I take full accountability for my actions and I'm very remorseful, but at the same time, I know that I learned a lot from this experience. I'm not the same person I was a year ago. I just want to move forward in my life and just be a better person for my family, for members of my community, and just get past this and just move forward. I'm too old to be making mistakes and
But the question is, why do you, I mean, these are not mistakes, these are choices. Why do you keep making the same choices? Because you have previous convictions for assaultive behavior. That's why this is a assault with a second conviction. So why do you keep making these same decisions? And then we have the violation of protective order. So there's a protective order in place. And when people violate protective orders, those are court orders. So that tells the court if you're violating that, then you won't follow my orders because you're already violating the court's order.
I was under the influence of drugs and I
I'm
just,
sorry,
I
what?
was under the influence of narcotics, Your Honor, and I'm just trying to seek opportunity for treatment.
But I mean, yeah, you're under the influence of narcotics, but it didn't stop you from going to the location of the complainant and striking the complainant.
I was living there, Your Honor.
But wasn't there a protective order for you not to be at that location?
Not to my knowledge, and not until I was arrested was I informed of the protective order. My ex never told me about it.
Okay. All right, is there anything else? And on this case, what I can tell you, I don't have the trial court certification of defendant's rights to appeal. I know you probably filed it, but it's lost somewhere. So if you could do another one for me, please?
Yes, Judge, would that be one I have to get from them or do they have them on? the wall?
They should have them on the wall now.
Yes.
He took the last one.
Oh.
The clerks
Yeah,
may
be
have
quick,
some
man.
more. All right, the cause number is 2025 CR 0000069.
Things go like hotcakes, Your Honor, these nice ones.
Oh, yeah.
They're custody. They repeat this, and it's just a formality of the. What's that? The honor, can we tender it?
Yes, thank you. All right, any further witnesses?
None from the state, none from the defense, Your Honor.
All right, so Mr. Chamberlain, I want you to know your attorney did a very good job for you because you have numerous cases that are open and pending, right?
Yes, Your Honor.
I just don't think that you're a good candidate for probation. So I'm going to find you guilty. There's an affirmative finding of family violence. There's to be no contact with the complainant, a $1,500 fine, time and money to run concurrently. This will run concurrent with 2025 CR 000071, 2025 CR 000092, take in consideration 2025 CR 00070, 2025 AL 002118. Court will give you credit for any time served, the therapeutic community, and 5 years in the prison. With the therapeutic community, I have no jurisdiction to mandate that you be in the program, but they'll know in the judgment that I'm requesting the therapeutic community for you. So there may be either mental health issues or drug issues. You're still going to have to request the program. You understand? All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
That's right.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
That's right.
All right, we can go off the record. So here's the thing. When you are released from the prison, if you can't find a place that can help you with your addictions, you can always come back to here. If I'm here, then I will see if we can find a placement for you, okay?
Thank you.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome. And if y'all can see what's going to happen with the remaining cases, please.
Yes, Your Honor, I will definitely check up on that.
All right, thank you. The court is calling Joseph Joshua Harris. Where are you?
Good morning.
Good morning. So where are we on discovery?
Judge, it's something that I might have, well, I want to bring up to the court.
I just- this. And we will see what we're going to do, okay?
Okay.
All right, so Ms. Ferguson, on this case, can I get a 30-day reset? And we may end up bringing you back sooner than this, but this is just to give the court more time and the state and your counsel more time to confer with each other.
Okay, Judge, yes, ma'am.
All right, so we'll be back on August 14th. All right, thank you.
Thank you.
Who's here on Johnny Galvan?
Here for Mr. Garcia.
Yes. And Mr. Galvan? Come down, please. How's he doing?
Let's see the doctor who is now referring to.
Let me ask you this. Who's appointed on these cases? Would you like to be appointed on these since?
If that's fine, Judge, if that helps you, that's.
Well, I mean, so that his client.
For this particular, but the other who's up there as well, Pedro Rodriguez, he's hired, so he's hired on that one. Yeah.
All right, and this one is appointed, correct?
Correct.
All right, Norma, on this case, could you put Ms. Christian down as co-counsel?
Perfect.
All right, so what I'm gonna do, your attorney is ill, right? So I'm gonna recall this for discovery, so this attorney can get up to speed on everything.
Yes, ma'am.
All right, Norma, if I can have 3 weeks on each of these, please.
I think on Mr. Rodriguez's case, he just wanted it set for trial. But
All right,
however
well,
you want to do it.
August 5th.
August
all right, it's gonna be August 5th. State on Johnny Galvan on August 5th. You'll need to be prepared to tender an offer.
Yes, Judge.
All right, Mr. Galvan, I see you're a Padres fan. All right, so they're gonna take you back unless you have anything else to discuss.
No, and then I'll check out that discovery and I'll make something happen.
All right. All right, sir, you can have a seat back in the box. And then who's the other person?
The other one is Pedro Rodriguez.
All right, Pedro Rodriguez. All right, what I'm gonna do with this case, your attorney is still counsel. I'm just gonna put this as August 5th as well, so maybe you can have an update for us.
I definitely will do that, Judge. But if you'd rather, he just asked me to set it for a trial setting, if that makes it more expeditious. Either way you want to do it.
Well, let's do an update
Okay, got it.
on that date, and then after that, I'll do your trial set. Perfect. So on August 5th, we're gonna come back for this case with an update on counsel's health.
Okay, yes, sir.
Because I don't want to set it for a jury trial date if he
Gotcha.
has
Yeah.
more time than he's gonna be
Okay.
out.
No worries.
Is that the same page?
Yes.
Yes.
And what page is he on?
He's on the first page.
Thank you.
And so you guys are good on?
Yes. All right, thank you.
Thank you, Judge.
Thank you, Judge.
You're welcome. All right, John Anthony Robles. And are these applications or none?
No, Judge.
Okay. Court is calling 2025 CR 006650, 2025 CR 006653, State versus Don Anthony Robles. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
And Brandon Jackson for John Douglas.
And are you Mr. Robles?
Yes, Your Honor.
Counsel, have you received all discovery that you reviewed with your client?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, Mr. Robles, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State in the cause number ending in 50, are you proceeding on the indictment as presented?
No, Your Honor, the state is waiving and abandoning the repeat offender enhancement.
Any objection?
No objection, Your Honor.
And in the cause number ending in 53, are you proceeding on the indictment as presented?
No, Your Honor, the state is also waiving and abandoning the repeat offender enhancement.
And no objection, Your Honor.
All right, Mr. Robles, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in each offense you're charged with theft of property less than $2,500 with 2 or more previous convictions? As state jail felonies, range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering these pleas, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Robles, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. The state is waiving the enhancement paragraphs. There are no applications. The cases will run concurrently and there's to be no contact with the complainants. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State,
Yes, Judge.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There are not, Judge.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 and all attachments in both cases respectively are on.
No objection, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you agree the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
Yes, Your Honor.
All right, after reviewing State's Exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, I just respectfully ask that you follow the agreement. He's ready to get on with his life. He said he's done with this type of life and ready to move forward.
All right. And the cause number ending in 5-3. The court will follow your agreement, sentence you to 1 year in the state jail facility, give you credit for any time served. This is run concurrent with 2025 CR 006650. And there's to be no contact with target. And I'll request the therapeutic community. And the cause number ending in 50. The court, as previously stated, is finding you guilty. The court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2025 CR 006653. There's to be no contact with China King Buffet. And I request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. If you continue doing what you're doing, only one or two things going to end up happening. You're going to end up spending the rest of your life in prison, or somebody may end up killing you because you're stealing. And this is Texas, okay? All right, good luck to you, sir. All right, Jorge Jimenez. Who's the person for her? Is the attorney for Jorge Jimenez here? Okay. Mahmoud Al-Gadrab. The attorney for Mahmoud I'm sorry, sir, your attorney's not here.
Oh.
Mahmoud Al-Gadrab, who's the attorney? All right. Enrique Talamonte Segura.
Sure, President.
All right, if you'll come down, please.
I'm on this. Yeah, keep following.
No, I don't have Escobedo's file. It should be up there. All right, so we're set today for discovery. Are there still discovery issue? Need an interpreter?
Yes, Your Honor.
Okay.
Good morning.
Good morning.
I was ready for the other case, so.
Oh, that's okay. It's a crazy Tuesday, but it feels like it's Monday.
I know. Ready.
Hello. All right, so counsel, we're here for discovery. Where are we on discovery?
Yes, Judge. So on these three cases, I submitted three respective motions for discovery on this case.
All right, it's 3 cases.
Yes, Your Honor. Well, yes.
Okay, I only have 2, but okay. All right, you may proceed.
The state gave me some additional, well, an affidavit of search warrant, Judge. And so I believe based on what I read, the only discovery that I would need is, if the state has it, is the surveillance video from essentially some drones that were on the property when this incident occurred.
All right, and guys, Talamantes Segura has 3 cases. I only have 2. All right, are all of these cases alleged to happen on the same day?
Yes, Your Honor.
So there will be drones, potentially drones in everyone?
Yes, Your Honor.
I believe a lot of this is uploaded to the Veritas and the discovery, and that's where I got the search warrant from, so I don't know if you kind of said opportunity to do that or not, so some of it should be there. That's what that.
Yeah, we received a lot of discovery. Judge, I've gone through some of the videos, body worn cameras, dash cams. I haven't seen the drone video yet, but I'll look for it. And if I can't find it, I'll let Jason know.
All right, so what we'll do is we'll reset this for 30 days for one more discovery setting. I need a 30-day reset for discovery. All right, August 14th. And is your client a citizen?
No, Your Honor.
Does he need an immigration attorney appointed?
Yes, Your Honor.
All right, so Norma, we need immigration attorney from MAC on this one.
Yes, I'll do it. Of course. Yeah, I'll get that done today, Judge.
All right, thank you. Is there anything else?
Nothing further from defense, Judge.
All right, and Mr. Segura, is there anything else?
No.
All right, thank you.
They did.
Thank you.
You're not.
Who's here on Cameron Scott?
Here's Scott, Mrs. Scott.
Yes. Are you okay, Mr. Cox? Do you need a cough drop? We've learned to keep cough drops. Oh, okay. All right. Let me pull him up.
Motion for early termination.
Ah, yes. All right, State, do you have witnesses?
Your Honor, I do believe this is the second attorney on this case. The previous defense attorney had agreed to let our complainant testify by Zoom. My understanding is that Mr. Cox would be objecting.
All right.
I would like to.
All right, so we'll reset it and then we'll need the complainant present.
Yes, sir.
All right, so how much time do you need to have your witness?
Your Honor, if I could just check with her and see when she's available.
Okay. All right. So if y'all have a seat.
But I attached an email of the regarding this about.
There's no email. Things are disappearing. All right, Jose Sanchez. Court is calling 2025 CR 005279 State versus Jose Luis Sanchez. Could I have parties announced?
Megan Galloway for the state.
Albert Chavez for Mr. Sanchez.
And are you Mr. Sanchez?
Yes.
All right, we have an interpreter here. Could you raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right. Counsel, do you speak Spanish?
I do.
Do you speak it fluently?
Yes, I do.
And were you able to review these documents in Spanish with your client?
Yes, I was.
Mr. Sanchez, all of the documents I'm going to review with you are in English. Were those documents reviewed with you in Spanish?
Yes.
Mr. I'm sorry, there are no applications?
No,
Okay. Counsel, have you received all discovery? Did you review it with your client?
we did.
Court will find that the state is in compliance with discovery. Mr. Sanchez, did you review the true bill of indictment with your attorney? Did you understand it?
Sí, yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Sanchez, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with driving while intoxicated third or more as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was.
Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 5 years in the prison. This will run concurrent with 2019 DCR 01247E. And there should be $60 to DPS for testing. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
No.
This paragraph here in the document, the waiver of appeal paragraph, did your attorney review that with you?
Yes.
All right, did you sign it?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counselor, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offer states one in attachments.
No objection.
All right, state, you may be excused.
Yep.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine, and confront any witnesses the state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are.
Anything you wish to say on behalf of your client?
No, Judge, he's just ready to get this taken care of.
All right. The court will sentence you to 5 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. This is run concurrent with 2019 DCR 01247E, and there's to be $60 to DPS for testing, the therapeutic community, and 2 years license suspension. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. You're one of those people who cannot drink alcohol. You can easily kill someone while you're driving intoxicated. So I'm requesting the therapeutic community for you. Once you're released from prison, if you can't find a place to help you maintain your sobriety, if I'm still here, you can come back here and I will find a placement for you, okay?
Okay.
All right, good luck to you. Thank you.
Thank you, Judge.
Thank you. Do you need me to sign anything?
No, we're good. Thank you.
Thank you.
Thank you, ma'am.
All right, do you have a date on Cameron Scott? July 31st? And what page is he on? Thank you. Edward Castillo? All right, today's plea deadline date.
Judge, we just got some new discovery today. I would.
What is the discovery?
The IDR, incident detail report. I'd ask for.
Additionally, Your Honor, there has been mention of a co-ban video that may or may not exist, and the state is making a request into that. It was brought to the state's attention today that we may not have had all the full co-ban.
All right, Ms. Ferguson, if I can have a 3-week reset for discovery. All right, once you sign the reset form, you're excused. Dejanette Havana? Marco Moreno? Oh, it's for the last witness? Just give me one. Who's the interpreter for Marco Moreno? Can you give me 2 minutes? All right, thank you. Dejanette Havana.
Good morning.
Good morning. So you're scheduled for jury trial today. We are currently in a trial. So I'm going to recall this for tomorrow and we'll see where we are.
Your Honor, we have filed a motion for continuance because of a subpoenaed witness who is one of our material witnesses in the case. It's the vet who saw the.
Okay, so I don't have the motion. Can you have them pull it?
I can pull it. I have it.
All right, thank you. And State, are you going to be an objection to their motion for continuance?
No, Your Honor, and I believe in the motion, defense alluded to the fact that the state would be in agreement.
All right.
Thought I had it, Your Honor. I have it. Okay. I apologize.
No problem. The systems were down, so things are sort of like moving fluidly. It's all fluid. We're gonna go on the record in 2025 CR 001454 State versus Dejanay Miller Havana. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Jody Sawyers for the defense.
And are you Miss Havana?
Yes, ma'am.
All right, defense. The court's understanding is that you're asking for a continuance?
Yes, Your Honor. We have an expert who is on vacation from yesterday, which was the 14th, until August 10th. And then I have a vacation on file with non-refundable tickets starting on the 15th, the night of the 15th through the 23rd. I'm asking that we be reset to the 26th, which is that Tuesday immediately, the first Tuesday available. I'm also special set in your
All right,
case.
let's do this. Let's start with the motion for continuance, then we'll go on to other things. I like to do things in a specific order. So the court is reviewing the defense's motion for continuance. And State, my understanding, you're in agreement?
Yes, Judge.
All right, so first things first, motion for continuance will be granted. All right. Do you have all discovery?
Yeah.
Okay, so I need a acknowledgement of discovery if one hasn't been filed.
It's already been filed. We filed it when Angeline was here.
Okay. Then the next thing I need, if you all would confer with Ms. Ferguson on a jury trial date and then come back to me with a date.
Okay, thank you.
All right, thank you. Moreno. And you have the witness who needs an interpreter?
I just have two more, who would be my last one then.
All right, so let's do the one who needs the interpreter first.
Okay. You've gone to the restroom, I apologize.
Okay, all right, just have a seat.
Okay.
Jorge Jimenez. Is the attorney here? The email? Come forward. All right, your attorney, we just received an email.
Yes, ma'am.
So Ms. Ferguson, recall this for July 22nd. All right, once you receive the reset form, you excuse.
Okay, yes, ma'am.
Thank you for your patience. All right, June Bright. Is the attorney here for June Bright?
Yes, right. That we did, I did some over the day.
Just give me a moment. On, all right, then we'll do, I'm sorry, August what? All right, your jury trial will be August 26th.
Okay, thank you, Your Honor.
Thank you.
Thank you.
All right, where are we on discovery?
Discovery has been completed, Judge. I received an offer today and would like to set it for the final of the plea deadline.
All right, Miss, how old are you?
61.
All right, Miss Ferguson, if I can get a plea deadline date on Miss Bright for 3 weeks, please.
I'm gonna be out of town that week, Judge. I can do the week before, or the week after.
All right, Norma, week before or week after? And are you employed, Miss?
Yes, ma'am.
All right, what's your work schedule?
I work at lunch out in Burger Place.
No, I mean, what's the schedule?
I work at night. I work from 5 to 10,
Okay,
Monday, Tuesday, Wednesday, and then Thursday, Friday. Monday, Tuesday, Wednesday.
All right, so
Thursday,
what's-
Friday, Saturday, I work until midnight.
all right, so what works best for you? What day of the week?
For what?
for a plea, to come to court.
Oh, I'm available anytime during the morning.
All right.
I don't go in until evening.
All right, Ms. Ferguson, can I have a date, please?
That'll work, Judge.
All right, so we'll be back on August 12th.
Yes, ma'am.
People reset things and then we always forget to ask, what's your work schedule? It would always irritate me as a defense attorney when people would say, oh, this doctor can't be here. But then when you have somebody who's doing manual labor, that's really where the employer will fire them at the drop of a hat. So, all right, we're going to bring you back on August 12th. Just sign the reset form, then you're excused.
I'll bring it to you.
Oh, what? There we are. David Escobedo. Is the attorney here for David Escobedo? All right, just have a seat. Mahmoud Al-Gadrab.
Are you here?
And then after that, Moreno is the witness who needs the interpreter back.
It was actually a switcheroo. Everyone's here.
All right, so you'll let him know who the witness is. All right. So where are we on discovery?
Your Honor, I believe it's substantially complete, but there's some discovery on my end that Megan and I spoke about today. In order for her to make an offer.
All right,
My
so,
client's been out, he was hospitalized, he's been coughing and hacking.
oh,
He tells me he's not contagious, but
wow.
so.
You know,
I'll be
when
getting
COVID
with
first
him.
started, when people would cough, everybody would,
I was almost missed court last time,
Mhm.
but I told him I need to give release today.
no, here's the thing. Do not force people to release you from the hospital for court.
Mhm.
All your attorney has to do is get a note to the court that you're in the hospital and that will be fine. We don't want people coming in sick.
I didn't want to take a risk.
Oh, no. We don't do that. So you need to, if you need to be back at the hospital, you need to let them know that you need to be back.
Okay.
in. And so go readmit yourself.
No problem.
All right, if I can have a 3-week reset for discovery, please. All right, August 5th, once you sign the reset form, you are excused. All right, Marino. August 5th is final discovery. Yes. And it's defense discovery. All right. We're back on the record in 2024 CR 006824. State versus Marco Marino. Defense, you have another witness?
Yes. At this time, the defense calls Juan Moreno to testify.
And is he the person who needs an interpreter?
No, I apologize for that. There was a misunderstanding.
So there's no witness who needs an
There
interpreter?
is, she's coming after.
No.
You want,
We need that person first because the interpreter has other courts they need to go to.
okay, I apologize. for
No
that.
problem.
So at this time, we would like to, you'll be coming back, but we would like to call Oralia G. Velazquez to testify.
And if does she need a chair? Could somebody get her a chair, please? Thank you, Duffy.
I just asked her if she was hard of hearing, but she said she could hear fine.
All right, thank you. And the interpreter, you're still under oath.
Yes, ma'am. Thank
All
you.
right, Miss, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. So make sure you keep your voice up so that the interpreter can hear.
Okay, that's fine.
All right, defense, you may proceed.
Ma'am, could you please state your full name for the record?
My full name is Oralia de la Vida Velasquez.
And could you please spell your name for the court reporter?
Galadis de Vasquez.
Oralia Galadis Velasquez.
De Vasquez.
De Vasquez.
Are you able to spell your name letter by
All right,
letter?
so let's do this. If no one has any objection, is there anyone here who can just give a note to the court reporter for the spelling of her name?
Yes. I
All
can
right.
do that now. if we-
We can do that after testimony. So is there any objection to that? Is there anyone who believes that the witness is not who she says she is?
No, Your Honor.
All right, you may ask your next question.
And Mr. Vasquez, what is your relationship to Monica Moreno?
Es mi relación. Es buena relación.
We had
Llevamos buena relación mi hijo y yo.
we have a good relationship, my son and myself.
All right. And so if your son were to be released from jail and granted deferred adjudication, community supervision, where would he be living?
Sería vivir conmigo.
He would go to live with me.
And where do you currently live?
En 2618.
Have in your life at the time of his arrest?
Él estaba conmigo, cuidándome, ayudándome.
He
Porque
was,
ya estaba enferma.
he was with me, taking care of me when I was sick.
And how has Marco helped you with your current health problems?
Pues ahorita muchas veces no me puedo levantar. Estoy sentada y él me da la mano. Me llega a mi pantalla.
So right now, since I can get up, he's sometimes fix me up. He grabs me by the arm and he takes me to my bedroom or the bathroom.
And just to be clear, this was before he was incarcerated in the jail.
Yes, before.
And how would your life be affected if Marco were sentenced to a term in prison?
Sería muy triste para mí.
It would be very sad for me.
Yo pienso que yo recaería más
I think I would relapse even more.
de lo que ya estoy. Y
Of
me
what
van
I
a
am.
hacer una cirugía y él podría ayudarme.
And I'm gonna get a surgery so he could help me with it.
And what assurances can you provide the court that Marco would follow all terms and conditions of deferred adjudication if the court approves that application?
Él ha aprendido mucho de esto.
Yes.
Y ha pedido perdón a Dios y a nosotros también.
He has learned a lot through this and he has apologized to God and to himself as well.
And what more would you like the court to consider when it is reviewing Marco's application for deferred adjudication?
No tengo quien me lleve a las citas médicas.
I would like her to consider that I don't have anyone to take me to the medical appointments.
Pudiera tener la posibilidad de que él me llevara.
And if I could have the possibility for him to take me to those appointments.
All right, nothing further, Your Honor.
Any questions?
Yes, Your Honor.
Gracias.
Good, sorry, you can proceed. Good morning, Ms. Vasquez.
Good morning.
And you know that Marco has been incarcerated for about a year now, is that correct?
A little bit more than a year, yes.
A little bit more than a year. And you have your other children here in San Antonio? And they've
Yes.
been helping you for the past year while Marco's been incarcerated?
Yes. Struggling because they are working.
But they've been able to take you to your appointments and go visit you at your home.
They visit me once in a while or they call me.
So how have you been getting to your appointments for the past year?
My daughter has been taking me, but she has been missing work. And another of my children also has to get work so they can take me.
And who do you live with at home?
One of my children lives with me.
Okay, and so they're helping you while Marco's been incarcerated around the home.
Not very well because he doesn't have enough time to also be working as well.
So I understand they all work, but how have you been getting around your home?
He cooks his own meals. He washes his own clothes. He helps me a little bit, sometimes he sweeps. But pretty quickly, you know, and sometimes we don't like the way they do it.
That's fair. You said something that I wanted to ask you about. You said that Marco apologized to God. What did he apologize for?
He apologized for coming here, and I told him once, I never want to step in a courtroom. And when the police came, I really felt very bad.
So, and let me just make sure I understand. You're saying he apologized to God for having you come to court, or did I mishear you?
I always tell my children that any bad act or any bad thought, I will tell them, forgive yourself and ask for God's forgiveness.
So is it your understanding he was apologizing to God for what he did to Sarah?
Or anything. I don't know up to what extent my daughter has done something wrong. I don't know exactly.
What do you know of the charges that we're here for today?
I really don't know because I forget a lot. I have that problem that I forget things.
No further questions from the state.
Any other questions? All right, Miss. Hi. Thank you so much for coming down. And I want you to know that I appreciate your testimony. I always say, just tell the truth. Whatever you say, don't worry, it's not going to hurt your son, but it has given me some insight into your son, okay? Janata. Oh, thank you. God bless you too. Oh, thank you. I appreciate all the prayers. All right. Thank you so much. Thank you. All right, call your next, and I think that's the last.
Yes, the defense called its last witness, Juan Moreno, to testify.
All right. Hello, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. State your name for the record.
Juan Manuel Moreno.
All right. And I'm assuming you're his brother?
Yes.
You all look exactly alike.
Yeah.
All right, you may proceed, counsel.
So you stated to Judge just now you are Marco Moreno's brother. Are you his younger brother or his older brother?
Old brother.
And how would you describe your relationship with Marco?
Oh, it's a pretty good relationship, pretty close.
How long would you say you've been close in your adult life?
In adult life, pretty much more. All of our adult lives, we keep in touch. Sometimes we don't communicate for weeks, but if he's busy with his family, I'm busy with my family, and then we have get-togethers, and it's always been good.
And so in the time that you've known Marco, specifically in your adult life, what do you know of his work history?
Well, his last couple of jobs, I know he's lasted about 7 to 8 years on each one.
All right, and to your personal knowledge, where was he employed at those 8-year periods or 7-year periods?
Let's pass he was working for pharmaceutical delivery. And then before that, it was Walmart.
And what was he doing at Walmart?
I think he was a stalker.
And to your personal knowledge, was he working at the time of his arrest?
Yes.
And so what kind of work would you expect to see Marco pursue if he were released and he was granted deferred adjudication by this court?
I would imagine he would pursue the same type of work he was doing, delivery driver.
And what assurances can you provide the court as Marco's brother that he will comply with the terms and conditions of deferred adjudication if that is granted?
I'm pretty sure, knowing him, I'm pretty sure he will comply to whatever the court dictates for him to do. I'm confident he is responsible.
And how is he responsible? What examples could you provide?
Well, basic compliance with the law and with family and his children.
And how many children does he have?
He has 2.
All right. And what more would you like the court to know as it considers Marco's application for deferred adjudication?
I would like to tell the court that if he was to be under that condition, that he has the full support of all of myself, my brothers, and my sister, my mother. And also to this day, I trust him. I have always trusted him with my daughters. He's, I think he was the favorite uncle. And since they were babies till now, they're full-grown women.
How old are they now?
26, 30, 31, and 32.
Thank you, Your Honor. I pass the case.
All right, yes.
Briefly, Your Honor. Good morning, Mr. Moreno. So I did want to ask you a couple questions. You said your daughter, you have how many daughters?
3.
3 daughters. And correct me if I'm wrong, you said they were all over 25.
Yes.
Okay. Do they have any grandchildren?
Yes,
Or do you have any?
I have grandchildren. I have there's so many. Because I have stepkids also. So altogether I have 11.
Okay, so 11 grandchildren. What ages do they range from?
From 23 to
To 2? Okay, so little ones as well. And you said something earlier. You said you trust him with your daughters.
yes.
Okay. And you trust him with your grandchildren? And what do you know about the charges that we're here for today? Not if they're true, but what do you know about them?
Well, I know he was accused of doing something to the victim, but I don't know if it's true or not.
And that's not what I'm asking. I'm just simply asking what you know about the charges. So you said he was accused of doing something to the victim. What is your understanding of what he did to the victim?
What I understand is that she was touched inappropriately.
Do you know for how long?
No.
Would it surprise you to know that it occurred from the time she was 5 until she was 14?
It was,
And I'm just asking because you said earlier that your brother is responsible because he's complied with the law, but you would agree with me that if he's violating a child from the ages of 5 to 14, that's not complying with the law, right?
of course.
And knowing that those are the charges that we're here for today, you still trust them with your children and your grandchildren. So you would still let them hang out and have a part in his life. Any further questions?
All right, thank you so much for coming down. I want to let you know that I just want people to be honest when they're testifying. So there is nothing in your testimony that, hurts your brother. You're just coming down to testify and give the court insight into him. So I appreciate your giving me some insight into your brother. All right, thank you.
Thank you.
All right, any other witnesses?
No, sir. And Your Honor, before we do continue, the state did receive the victim impact statement from the complainant. Pursuant to Article 56A157, it was supposed to be with the court and to be considered by the court before sentencing. So the state would tender that pending any objection from defense.
No objection, it's been disclosed. Excuse me.
All right, the court has reviewed the statement. All right, so here's the thing, sir. The state has offered you a cap of 12. That's their offer. So somebody should explain to the court why I should accept this offer, because the charge is aggravated sexual assault of a child. State, you're saying that this happened over years, many years. So why should,
If I may,
yes,
it was originally continuous sexual assault and then it
Yes.
led to just one count.
yes. So they just pled to one count. So people want me to review the victim impact statement and review all of this. So my question is, why should I be following an agreement of a cap of 12 when I'm assuming, state, you're saying that this is a horrendous offense that has occurred? So why should I follow a cap of 12?
It is, Your Honor, and we have spoken with the complainant and with her family. And given the assurances of trial and given the fact that the complainant would have to relive her testimony and everything that happened to her while testifying on the stand, this was the agreement that the family, the state, and defense all came to.
And how old is the complainant now?
The complainant now, I believe, is 16 years old.
All right, because the victim impact statement that has been given to the court to review says that it appears that the complainant feels partially that this is her fault because you have other siblings or talking about they want their father back. So I've been handed something that it appears that the complainant is feeling the pressure that this is somehow her fault. So she's going to be 16.
And Judge, if
Yes.
we may interject.
Yes.
Regarding this plea, it involved multiple conversations, extensive review of the evidence. This court approved an investigator to assist in reviewing that evidence. And if you look at the report, indeed, it is voluminous. There are many allegations here, but there have been some that were demonstrated to be unsubstantiated, and that was also taken into account during negotiations.
All right. Anything else, State?
No, just that we have spoken with the complainant, and I understand what the court is saying, how the complainant in that statement may be saying that she's feeling pressure, but the state did speak to her by herself and did go over this offer with her and with her family, and this is what they would like, and this is what the state believes is appropriate.
All right, Mr. Moreno, your attorney has done extensive work on this case for you. She's done a great job from what I can see. The witnesses that she was able to obtain on your behalf, and the offer that she was able to negotiate to limit your liability, because on an aggravated sexual assault of a child, your liability really is 5 to 99 years or life in prison. And on the continuous sexual abuse of a child, your liability is a minimum 25. And if on a continuous sexual abuse of a child case, if you're giving 25 years, you do 25 years. There is no 2 for 1 or good time, or there's none of that. There is no parole. So your attorney did excellent work to have this moved from continuous to aggravated sexual assault of a child and to a cap of 12 years. The court is going to find you guilty. The court will sentence you to 12 years in the prison. There's to be Chapter 62 compliance. There's to be no contact with the complainant or any minors. There's a $1,500 fine. Time and money to run concurrent. Give you credit for any time served. And there's to be no residing with minors. And let me see. Did you review, I'm sorry, counsel, if you can have him sign the trial court certification. I know you probably did one previously.
We did.
But it's been lost somewhere in the system.
Because of Odyssey?
Yes.
All right.
We can blame everything on Odyssey.
Would you need to do the certification first before he signs on to it? Or-
No, he needs to sign it first, and then I'll tell him what my ruling is on whether or not he can appeal.
Okay,
Oh, if you could just have him sign that.
right here.
Yes,
Okay, I apologize.
no problem.
And then you need my information here as well.
Yes. No problem. Just make sure it goes back with the court report. Okay, thank you. No. There's no one here. And we're taking out break now.
Yes. This is the sign.
Thank you. All right, Mr. Moreno, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Am I understanding there's victim impact statement?
Yes, Your Honor.
All right, if you'll stand over there, please. Thank you.
Thank you.
All right, everyone, court is going to take its recess. Attorneys, we are starting up a jury trial at 1:30, so we will take you up during our breaks for the jury.